Good evening, ladies and gentlemen. At this time, I would like to ask all in council chambers to turn off or at least to vibrate your cell phones and electronic equipment. Today's date is December 7th? 6th. Thank you, Walter. And the public hearing of the Stratford Zoning Board of Appeals will come to order to hear those petitions advertised for this session. For those of you not familiar with our process, each petitioner or their designated representative will present their case to the board. When they have concluded, board members will then have the opportunity to ask any questions they may have. I will then ask if there is anyone who wishes to speak in favor or in opposition to the petition. We ask all petitioners to speak clearly and directly into the microphone. After all petitions have been heard, we will then recess to our administrative session. Interested parties are welcome to stay. However, only board members and staff will be allowed to speak at this time. Please be advised that clapping or shouting as a way of expressing opinions on the application is not allowed or tolerated. Item 1 is a continued item from last month, which is 55 Washington Parkway. And at this point here, the public hearing is still open. Mr. Knott.
Good evening, Ms. Young, Madam Secretary, Mr. Chairman, members of the board. My name is Barry Knott. I'm a lawyer with the firm of Knott, Dunn with offices at 1656 Main Street, Stratford. I'm here this evening on behalf of DPT Realty, LLC, the manager of which is David DeCilio, who lives at 6020 Main Street, Stratford. As an early Christmas present to the board this evening, I am not going to subject you to yet a third presentation on this same project because I've already presented to you in September. Then there were some questions raised by the town engineer and the fire marshal, which caused the public hearing to be continued. The continued public hearing, and Alex was requested to write a supplemental legal opinion to one he had written back in July. That second public hearing was in November, at which we had a lengthy presentation. Issues were raised about revised plans not having been submitted in a timely fashion. As a result of that issue, the public hearing was continued to tonight. I think you all remember what this is about. This is the roller skating rink on Washington Parkway. Our plan is to raise it and put up a 9-unit residential condominium project, the justification for which is a body of law that exists within the Connecticut zoning law that allows one non-conforming use to be converted to a less offensive non-conforming use without having to prove hardship. And that's the basis upon which we have come in for this approval. And I beat that horse to death at last month's meeting, and unless there are questions, I'm going to conclude my presentation at this time because I have nothing else to say.
Thank you, and I think we will accept that Christmas gift. Thank you. Just for the record, I'd like to state that Mr. Grega is sitting in for Mr. DeCilio, and I am sitting in for Mr. Jack Dempsey. You're concluded. I guess we have to go through any further comments from the public? Anybody in favor? Anybody in opposition? Seeing none, Ms. Young?
Are you taking further questions from the board? Because if so, I have some.
I'm open to that, yes.
Thank you. Mr. Knott, Attorney Knott, if I recall correctly, you gave us some of the copies of the case law that you referenced or excerpts from them.
Yes.
And the Hescock case, I believe, was one of those.
Yes.
Again, in support of your rationale for the granting of this variance being reduction in nonconformities, correct?
Yes.
So I've read the Hescock case, and there's a couple of points in it that if you spoke to it, I don't recall, so I'm going to ask you to speak to it now. The Hescock case talks about various tests of when reduction in nonconformities might be utilized as a substitute for traditional hardship. And some of those tests, my understanding is, we are supposed to consider whether there's any harm to the neighborhood
That's correct.
and considerations of public health, safety, and welfare of the neighborhood,
That's correct.
and whether or not the proposal in front of us is consistent with the comprehensive plan.
That's correct.
Thank you. So my questions relate to others I've asked you in the past as it concerns your proposed height relief. I believe you gave us some exhibits of adjacent homes and how they relate to your proposal, and my recollection is that they were not as tall as yours. And so I was hoping you could either remind the board, remind me how you believe your proposed height request relates to the case law and some of the items I just referenced.
Okay.
Thank you.
As far as the comprehensive plan of development is concerned, in this area of town, the comprehensive plan calls for residential use. This is residential use as opposed to the currently existing commercial use, which is the old roller skating rink. So we comply in that area. With respect to benefiting neighborhood properties, I believe we comply in that area because our proposed use represents an upgrade in use from a commercial roller skating rink to a residential. Now, with respect to your specific question regarding height, this use is a transitional use between the single-family houses that exist up Washington Parkway, all the way up Washington Parkway, and the commercial use that exists on the other side of this property, which is a hotel, a bar, and a restaurant. So this building is higher than the next house up the street. There's no question about it. However, you have to look at it as a transitional use where we're going from single-family residential to multifamily residential to commercial. That is a reasonable transitional use. And the understanding being that when you analyze the project from a global perspective and you see you're going from an offensive commercial use, which has now been abandoned for a decade or so, into a high-end residential use, that this project satisfies all of the components of the Hescott cases and the other cases that were cited in Alex and my memoranda. Sure.
If I may, I have heard you speak to how your proposed conditions relate to your existing conditions with respect to some of the relief that you are seeking from us, specifically setback and coverage and use. But I feel like we keep dancing around something I can hang my hat on to grant you the height relief. When I last asked you at the hearing in November, you told me you were going to increase the property values of surrounding properties, and that should be a rationale. Forgive me if I'm misquoting you. And tonight I'm hearing you again give testimony for why this use is better than the one that you are replacing. But my struggle personally, and why I, to give you a preview, could see me making a motion to grant in part and deny the height relief, because I'm still feeling like I need something more from you that I haven't received that tells me why the 36-foot height, if that's correct, that you're seeking, and when the underlying zoning district only allows 30, how I can rationalize that in the granting of the variance for that specific zoning standard. I'm persuaded on some of the others. It's that one that I'm struggling with.
Well, if you look at the plans of the individual townhouses, you'll see that this third room that is up on that higher floor is actually in the roof. In other words, we're taking advantage of a situation where we have a fairly steep roof and we're putting a bedroom in it or a den in it. So it's not like we're creating a whole third floor in order to have the benefit of this additional space. We're actually using roof area for a den/bedroom. What I said to you last time was that we are not claiming a financial hardship as justification for this proposal. We are not allowed to do that by law. However, the benefit of the third floor helps the applicant as well as the neighborhood. It helps the applicant by allowing the applicant to get more money for the units that he's going to be selling there, clearly. It helps the neighborhood because now instead of a $375,000 condo, you're going to have a $475,000 condo, so in your immediate neighborhood. So that's going to bring up the whole value of the houses that are on Washington Parkway. Before I was a lawyer, I was a real estate broker a long time ago. But what I learned was that when you are buying real estate, you want to buy the cheapest house on the street, not the most expensive house on the street. Now, why do you want to buy the cheapest house on the street? You want to buy the cheapest house on the street because that way the other houses on the street, which are more valuable than yours, will pull the value of your house up by virtue of the fact that it's in the same neighborhood. Whereas if you got the most expensive house on the street, the other houses on the street are going to pull the value of your house down. So here we have a situation where these units are going to pull the value of the neighboring properties up by virtue of the fact that they're going to be higher priced units. Listen, as you asked me and as I said to you at last month's meeting, the law that Alex quoted and that I quoted in our memoranda does not say that you have to approve this application under the Hescock case or the Adelson case and the other cases that were cited. It says that you can if you want to. You're allowed to by law. And if you're not comfortable with the proposal, then you shouldn't vote for it. What I'm saying is that I've been doing this in this town for 42 years. I've been standing at this podium making zoning presentations. In lordship, this is the first time that I have ever had an application that has had 3 public hearings where there was no public outcry from the lordship neighbors in opposition to whatever it was I'm proposing. I usually have arrows sticking out of my back on projects that are oriented in lordship, because lordship is a very active community. The people are vocal, they're educated, they're articulate, and if they don't like something, they come out. We have no opposition here, except for Walter. God bless you. He wasn't complaining about this project. He was complaining about some house 2 or 3 doors up Washington Parkway because it was so tall. So that's the justification.
Any further questions from the commission? Mary, you satisfied? You're not satisfied? You want to ask more?
I don't feel that I got what I needed, but I don't think it's worth asking the same question repeatedly. But thank you for the offer.
All right.
Thank you.
Seeing no other questions, I'll entertain a motion to close by Mr. Hoydick. I have a second, Mr. Taveras. All those in favor say aye. Aye. Opposed? So moved. Item number 2 on our docket this evening is the Dock Shopping Center and Ferry Boulevard project. And do we have Mr. Knott is going to represent them tonight also.
We already get your certificates, ma'am?
Yes.
Thank you.
All you have to do is stamp, you can just stamp the front folder. And then I'll... One in Mary, I'm gonna take.
So whatever he gave us off on the first petition, he's going to make up for it.
I'm sure. I'm sure.
Good evening, excuse me. Good evening, Ms. Young, Madam Secretary, Mr. Chairman, members of the board. My name is Barry Knott. I'm a lawyer with the firm of Knott, and Dunn with offices at 1656 Main Street, Stratford. I'm here this evening on behalf of UB Dockside LLC, also known as the Dock Shopping Center, 955 Ferry Boulevard, Stratford. At this time, I'd like to submit the certificates of mailing and make reference to a folder of exhibits which I have handed to each of you and to which I will be making reference during the course of my presentation. The first three of which are photographs of the area where we are proposing to put this boat showroom for which we are applying, variances for which we are applying. Exhibit 1 is a photo taken from the river back towards the entrance to the shopping center off of Ferry Boulevard, and you can see the sign there out on Ferry Boulevard. Then you can see the driveway coming down, and then the oil company guy and the mailman are hiding in the parking lot from their superiors, and it is having been a mailman, I know exactly what this mailman is doing. So it is in this parking lot where we are proposing to construct this 10,000 square foot structure. Exhibit 2 is another photograph of the same area, as is Exhibit 3. So this is where we're talking about putting this 5,000 square foot building. Now, when you look at these photographs and when you actually drive on the site, this is an area that if I hadn't shown you these photographs, or if you haven't been over there lately, you wouldn't even know this area existed. I mean, you drive right by it, you don't even know it's there. So it's a perfect location where we are proposing to put this facility. Exhibit 4 is a rendering of the proposed boat showroom. And Exhibit 5 is a global site plan of the whole shopping center, where I have highlighted in the lower right-hand corner the area where this proposed showroom is going to go. This is the whole shopping center on both sides of I-95. Exhibit 6 is a blow-up of Exhibit 5, and this gives you a closer view of the area where the boat showroom is going to be located. And I want to point out two things on this exhibit. First is I want you to take a look that the first floor elevation of the building is at elevation 12. And you can also see a rain garden located in front of the building between the building and the driveway in. And I'll talk more about both the rain garden and the first floor elevation of 12 in a moment.
Excuse me, I'm sorry to interrupt. Just point of clarification. We got some materials last month, and have a first floor elevation of 11. Has that been superseded by this exhibit?
Exactly.
Thank you.
Yes. Exhibit 7 is the floor plan of the first and second floor of the proposed boat showroom. Please note that the first floor space will constitute retail space for the sale of boats and boating accessories, and the second floor space will be used as a self-storage locker facility for people who have boats in the marina and it's wintertime and they got to move their stuff off the boat and they don't want to drag it all the way home. They can go up to the second floor, hire out one of these lockers, and put their boating accessories on the second floor. So the second floor is essentially storage locker areas. Now, Scott Mitchell currently operates the Boardwalk Marina down there, and he's going to be the one that's going to be operating the boat showroom. And I want him to come up right now and explain to you the idea behind this boat showroom, the need for it, and how it will be used. Scott?
Good evening, everyone. For those of you who don't know the area, the situation, we have been a marina operator there for about the past 10 years. The economy was kind of tough when we got there. We added rental boats, added the fuel department, and now we're getting back into the retail sale of boats. We've been lucky enough to pick up the Bayliner brand, and we are selling them out of the vacant retail spaces in the shopping center itself. So now we're looking to step it up a bit, so to speak, get into our own situation at the end, move all of the marina operations into one building, and offer a feature and benefit of storage, so everything's kind of self-inclusive for everybody. That's pretty much, inside's going to be empty and full of 20-foot, 25-foot boats. That's about it.
Any questions for Mr. Mitchell? Mr. Grega?
Will you be doing repairs on boats in this facility?
No, we're still going to maintain that out by Stop and Shop.
Okay.
Mr. Taveras?
Are there any kind of fire suppressive systems in this warehouse, other than the Housatonic, of course?
Not sure at this point. Whatever they require is going to be built.
Whatever the fire department
Yeah,
requires?
whatever the fire marshal says is what will go in there. Our current building has sprinklers. I just don't know the answer to that.
Will there also be any kind of hazardous fluids contained in the building, such as, fuel or?
I have to say yes, because we're dealing with fiberglass products. I mean, there'll be a gallon of gasoline in a new boat. There'll be engine oil in a new motor. There'll be wax, which, yes, but at the level of a repair facility or anything like that, no.
And they'll be stored in a certain area?
Well, yes. The most volatile substance we'll be dealing with, other than a little bit of gasoline that's in each boat or oils and fluids, is cleaning supplies. So no repairs, no gel coat stuff. That's all going to remain up on the other side.
Any other Ms. Young?
You asked if we had questions of this gentleman. I have questions of his representative.
I think his representative will be back.
Sure.
I'm sure.
Before I forget, I wanted to get full-size plans of the plans that you were looking at a moment ago, Mary.
Should I pass this around?
That would be, these are full-size size plans of the plans that are in your folders.
Thank you.
You want me to complete my presentation before you ask me a question? Okay. All right, Exhibit 8 is a letter from Carol Szymanski at the Department of Energy and Environmental Protection, which she wrote in response to the coastal area management application which we submitted. And in this exhibit, Carol says, the proposed first floor elevation of the building is 11 feet. While this is acceptable to build at base flood elevation, we recommend an additional foot of fire freeboard so that the first floor elevation is 12 feet. And as you can see from the revised plans that I submitted to you, we have bumped up that first floor elevation to 12 feet. Then she says coastal resources on or near the development site include coastal hazard areas, modified bluffs and escarpments, rocky shorefronts, intertidal flats, tidal wetlands, freshwater wetlands, developed shorefront, shorelands, near shore waters, and coastal waters. Downspouts could be directed to rain gardens to allow for some on-site infiltration of stormwater. Once again, the revised plan that I submitted to you has the rain garden in front of the building that she suggests in her letter. Finally, she says that since the proposed building provides boat sales and storage space and does include restrooms and showers for marina patrons, it will therefore provide upland support for the in-water marina use and be considered to support a water-dependent use. Exhibit 9 addresses partially Commissioner Taveras' issue, and that is an email from Brian Lampart, the fire marshal, to Jay, dated November 15th, in which Brian indicates, I've reviewed the documents provided pertaining to the proposed boat storage facility for the address above. At this time, I see no reason for concern as to the building type and location as it pertains to this property. As always, a complete review will happen at the time of application for a building permit. So Brian Lampart is comfortable with what we are proposing. Exhibit 10 is a letter from the Waterfront and Harbor Management Commission to Jay, dated yesterday rather. And I want to read, this resulted from a meeting that we had with the Harbor Management and Waterfront Commission on November 9th. And they indicate that following significant discussion with the applicant's representative, the Waterfront and Harbor Management Commission approved a motion to find the proposal is consistent with the Harbor Management Plan, with the understanding that the proposed project is intended to enhance the viability of an existing water-dependent use, Boardwalk Marina, and will not adversely affect public access to the nearby public fishing pier and along the shoreline. In addition, the Waterfront Commission agrees to provide the following comments to the Zoning Commission and you. 1, the design of the proposed building will reflect an appropriate nautical theme and be consistent with the town's greenway policy. 2, the Waterfront Commission supports best management practices for stormwater management, such as a rain garden proposed by the applicant to mitigate the adverse effects impact on stormwater runoff from additional impervious surfaces. And 3, the Waterfront Commission does not object to applicants' use of a temporary facility utilizing a tent and trailer to accommodate on-land boat storage during construction of the new facility, provided the temporary facility complies with all town requirements and does not adversely affect public access opportunities. Now, Exhibit 11 is an exhibit that we prepared that relates to item number 3 in the Waterfront Commission's letter that I just wrote. And this has to do with a temporary sail structure that is going to be used by the marina to house the boats that are ultimately going to go in the boat showroom, and they're currently located in the strip center itself where the new hibachi restaurant is going to be constructed. Scott's got to get out of there now because the Japanese hibachi restaurant is being constructed next to BJ's. And this, obviously, this building's not going to be ready for a number of months, so he's looking for a temporary trailer-type structure located where I show you on Exhibit 3. Now, this needs the permission from the Zoning Commission, and I am planning on submitting it to the administrative session of the Zoning Commission that's taking place later this month. I just wanted to show it to you for informational purposes. That's Exhibit 11. Now, in reviewing the file prior to tonight's presentation, I noticed that there was an email from Mary to Jay dated November 2nd, in which Mary requested supplemental information regarding this application. The first issue raised by Mary in that email was a question of whether the property will be in compliance with the minimum parking requirements should this application be approved. I'm happy to report that the property will comply with the parking regulations should this application be approved. If you look at Exhibit 6 with a magnifying glass, you will see that we have an additional 119 parking spaces over and above that which is needed to comply with the parking regulations regarding this site. And that's in the upper left-hand corner of that exhibit, which I've highlighted in yellow. Now, it's very difficult to see the extra 119 parking spaces on that exhibit. However, on the big board that I just submitted, you can see it easily. Secondly, Mary wanted to review any enforcement correspondence on file, specifically having to do with a complaint she had filed previously regarding the storage of boats alongside the street frontage for purposes of advertising on the site. In a memo, John Rosatsky, the zoning enforcement officer, wrote to the file dated November 3rd, 2016, he indicated that on 2 separate occasions during a few years back, he received complaints from Mary regarding boats being parked along Ferry Boulevard. A boat and jet ski apparently were parked along Ferry Boulevard with a sign indicating they were for rent at the Boardwalk Marina. John spoke to Scott Mitchell, who runs the marina, and indicated that John had received the complaint. Scott removed the boat and the jet ski promptly. Additionally, there is currently a boat on top of a large freestanding sign advertising the marina that you can see from I-95. And Mary had inquired about this, whether this was a legal sign or not. John indicated in his memo that that sign received a variance from the board in 2015. However, John mentioned that there is a steel I-beam structure with a mounted fish and jet ski located as an archway type of structure leading to dock access from the parking lot. John inquired of the building department as to whether this structure needed a building permit, and had one been applied for. It did need a building permit. One had not been applied for, but if you look at Exhibit 9, this is the building permit for that structure, which was obtained by Scott Mitchell today. Now, Exhibits 13, 14, 15, and 16 are copies of the tax bills and assessor's cards for the Dock Shopping Center. If you were to do the arithmetic, you would see that Erstad Biddle Properties, the owner of the center, pays $1,191,222.76 in taxes to the town of Stratford every year for this property. Now, I am not suggesting that a large taxpayer should be treated any differently than a small taxpayer by this or any other regulatory body. However, as economic development issues become more and more prevalent and important to the financial success of any town, state, or country, and all you got to do is turn on TV now and you'll see that economic development issues are in the forefront. It is incumbent upon all elected officials to represent their respective community to the taxpayers in as favorable a light as possible. Finally, I want to discuss hardship. I indicated in my application that the size and shape of this property and its proximity to the Housatonic River was the hardship. Now, typically, when I cite the size and shape of a property with respect to an applicant's hardship, it is because the size of the property is too small or the shape is so irregular as to justify a variance. That is not true in this case. Exactly the opposite is true. Here, the size and shape of the property is so large and expansive that to limit the number of buildings on site to one building, which is what your regulation section 1.24 says, you're allowed to have one principal building on a lot. When you apply that regulation to a shopping center site of this size, it's an unreasonable regulation. That regulation was written for small residential lots whereon only one principal residential structure was to be constructed. It was not intended for large shopping center properties. Additionally, this site is bisected by I-95, which, as you know, is a major interstate highway, adjacent to which is significant open space grass area, the aesthetics of which benefit this site. Additionally, the site abuts the Housatonic River, which is another significant open space area. Our regulations don't say that open space area has got to be grass or landscaping. Our river is open space. So we get the benefit of the aesthetics that apply to this site by virtue of being on the river. Clearly, the requested reduction in open space area on site from the required 20% to the currently existing 8% will have absolutely no adverse effect on this property. I would request that this application be approved by this board as expeditiously as possible, hopefully tonight. Currently, Scott's Boat Showroom is located, as I indicated to you, in the main shopping center building, but the Japanese hibachi restaurant's going in there, and he's got to move his showroom from this location immediately, hence the need for this approval and the need for the temporary trailer, for which I'll be asking permission from the Zoning Commission. Thank you.
Thank you. Any questions for Mr. Knott from the board? Ms. Young?
Thank you. Attorney Knott, if you could. perhaps educate me as it relates to signage. I'm accustomed to assuming that any merchant's signage needs to be affixed to the space in which they occupy. Are the Stratford zoning regulations more flexible to allow signage not affixed to the tenant's space, but they can be anywhere on the property? Specifically, I'm wondering about this archway signage to which you referred to. Your client now has a building permit, for which I'm grateful. Is that their signage? Is that advertising their business? And the fact that it's detached from their tenancy, does that matter in the Stratford zoning regulations? If Mr. Hibansky is better served to answer that question.
Oh, I can answer the question. Our signage regulations have two types of signs which are permitted. One are wall signs and one are freestanding signs. Depending upon the size of the building, the size of the property, and the size of the freestanding sign, the regulations are all different. But essentially, two types of signs, wall signs and freestanding signs. There are no other signs permitted under our zoning regulations. Now, with respect to the archway, I believe there is a jet ski that's located on that archway in addition to a guy with a fishing pole catching a fish. So that particular jet ski may be a problem. I haven't really researched it, but I can understand where you might find the jet ski to be an issue.
To your knowledge, again, I'm looking for education, how many freestanding signs is a tenant entitled to on a single lot? Are you limited to one, or is there no threshold? Because if I understand correctly from your presentation, there is a variance that allows the existing freestanding sign that you can see from 95, if we're calling that a freestanding sign. So this archway signage might be a second sign, so that sort of goes to my question, does that matter under the Stratford zoning regulations?
You can answer the question.
I'm only asking because we talked about the signage.
That's okay. Once again, hi. This was dealt with 4 years ago when the sign was put up. It was not a sign. It is considered artwork by this group of people 4 years ago. John will attest to that downstairs. I spoke to him at length today, brought him a sign permit. It's not a sign. It is an art support system, and that's what they wanted it classified as. It was done under a building permit, and that's the way they look at it.
That does answer my question, thank you.
You're welcome.
So it's not a sign, from what I gather, advertising any tenant, it's artwork to your clients.
Well, if you look at the building permit, which is submitted as an exhibit, it does make reference to artwork.
I think, hold on, Mr. Hoytick had a question, I think, to clarify something.
I have a couple of questions. One concerning the amount of impervious area, which was a concern of staff. Where will catch basins and water runoff be tied into? Is there an existing sewer system there, storm sewer system there right now?
Good evening, Mr. Chairman, members of the board. My name is Rob Aiello. I'm with the firm of JMC, and we're the applicant civil engineers. With regard to the stormwater management in the vicinity of the proposed building, there are some catch basins as you're up closer to the main building, but the southern third of the property drains by sheet flow across the driveway, through the parking area, and then into a drainage way, which then goes into the Housatonic River
So it drains in, eventually drains into the
by
river.
surface flow. And the improvements that we're proposing will not obstruct that from continuing.
Okay. All right, thank you.
Yeah.
I just have another question of Attorney Knott. Could you just go over your case for hardship on this?
Well, the hardship, as I indicated, is the size and shape of the property. The size being that it's such a large piece of property that restricting it to one principal building is not reasonable. And secondly, with respect to the open space requirement, the fact that the property is abutted, this particular side of the shopping center, or both sides of the shopping center, is bisected by I-95, which has grass and open space area adjacent to it, as well as the open space represented by the Housatonic River goes to the issue of whether an additional 12% open space on this site is going to add anything of substance to the project.
Okay, thank you.
I'm sorry, Mary, you were in the middle of questioning and,
Well, I did conclude my signage question. I was going to move on if you're done.
okay, well,
Okay. But I'll pick up where the gentleman left off in terms of trying to understand the hardship argument that you put forth. I'm curious to know if there was ever a discussion about the definition of a principal building. We have a very large multi-tenant building, and then we have this proposed building, which is, I think we'd agree, smaller. I wondered if that could have been considered an accessory building and therefore permissible, so as not to trigger the need for two principal buildings on a single lot. And I wondered if that had been vetted before this application had been made, because my next question, if the answer is yes, it was vetted, is why wasn't a building addition considered so that
The
you
answer
didn't
is
have
it was not vetted. And this is not the first time that this waiver has been requested and granted. You got to remember also on this site is Joey C's restaurant. On the other side, we've got Popeyes, separate building. We've got a gas station, another separate facility. And whether this building is an accessory building or a principal building, even though it's substantially smaller than the main shopping center building, it's still a 10,000 square foot commercial building. That's not an accessory building.
Well, that goes to the question maybe for Mr. Bansky. Is it even worth exploring if what our definitions identify the distinction between an accessory or principal building, and has that been considered? And I guess to Mr. Knott's point, I wasn't aware that we're now exacerbating, I guess, a non-conforming use of, there's multiple buildings on a site that's only supposed to have one building, which begs the question in my mind, was another alternative explored beyond a building addition, such as a text amendment? If this text doesn't work, then why is it still reading the way it does, and why wasn't the application made to the zoning commission for a text amendment before coming to this board, which I perceive as the board of last resort? I wonder if we've really exhausted all the other remedies that could have benefited his clients going forward and other clients going forward, so as not to trigger the necessity of a variance, since Mr. Knott wants me to be concerned about the economic future of Stratford.
Sure, well, it's been a discussion in my office recently because we've had a couple applications like this. And the regulation that we have is out of date. It does need to be changed. I can't speak to why the applicant has decided not to go for the proposal or go for a text amendment. Most likely because historically this is the way the zoning office has treated these applications. As Attorney Knott mentioned, that's the way they handled Joey C's, that's the way they handled Popeyes. Would it be more efficient for either the applicant or the zoning commission itself to propose a text amendment to say that multiple structures are permitted in a shopping plaza of X amount of square feet, making it exempt from the singular principal structure requirement? I think that would certainly make some of these hearings a bit more efficient and reduce some of the burden on the applicants. So,
I have a comment about this issue, if I may, Mr. Chairman. What Jay just said is absolutely correct. However, whenever you go to the zoning commission with a text amendment, the floodgates of opinion open wide. Suggestions are made to hire consultants to review this, that, and the other thing. And you find out that 6 months later, you're still where you were when you started. He doesn't have a boat show room. The town of Stratford has spent tens of thousands of dollars on a consultant to look at possible zone text amendments, and it isn't efficient. It's something that should be done. It's a long-term project. All of the zoning regulations need to be overhauled, not just this regulation. All of them. They're ridiculous. I wrote half of them. I know how ridiculous the ones I wrote are, but a zone text amendment is not the solution for expedient results. This is.
Okay, any further questions? Mary?
If I may, just back to the proposal in front of us, and thank you for the, again, additional education. I think you've heard that I have concerns about your client and signage on site. Going back to the Waterfront Harbor Management Commission's comments, since you were there and I was not, point number 1 in their December 5th letter talks about the design of the proposed building will reflect an appropriate nautical theme and be consistent with the town's gateway policy. How do you interpret that, and will I see more fishermen and jet skis that are labeled art appear on the rooftop of this building? Are you willing to accept as a condition of approval that we won't have many more of that?
Absolutely, we are willing to accept that as a condition of approval. There are not going to be any signs, jet skis, or anything inappropriate on top of this building, because this is located at the gateway to Stratford, at the bridge. We're very well familiar with that whole concept of the gateway approach. We're not going to put any jet skis that say "rent me" on it on top of this building, or boats or anything like that.
I think the gentleman needs to come to the microphone if he wants to speak.
Scott, if you want to speak, you'd have to come up to the mic, please.
It's never been brought to my attention that this jet ski, if that's what we're talking about, is an issue. And if it is, just like asking me to get a permit or anything else that's come up in the last decade I've been there, I'll be more than happy to fix. So I haven't heard from you or anyone else here or John or anyone in enforcement, but if there's something that's not right, let us know and we'll gladly take care of it for you. There's no hostility about it. It's just an unknown situation.
Thank you.
You're welcome.
So again, you've answered my question even before your client came up, but I appreciate his offering his opinion as well. Again, not having been at the meeting of the Waterfront Harbor Management Commission and not wanting to put your client between a rock and a hard place, I hope they didn't give him the opposite advice in terms of them trying to enhance the nautical theme. So that's why I wanted to understand better what were they getting at when they made that comment, if you know.
Yeah, I do know. I'll tell you what the discussion was at the Harbor Management Commission. This is a marina, 192 slips, a restaurant, maybe a boat showroom, but it's also the largest shopping center in the town of Stratford. So this is a shopping center that is located at the gateway to the town that also happens to have a marina as part of it. So in looking at this from a permitting perspective, we have to deal with it as a shopping center. It's got to be treated as a shopping center that has an accessory marina use. Now, Scott may not like hearing me say that, but I represent Erstad Biddle, the owner of the shopping center. And we have to maintain the integrity of this shopping center and improve the marina at the same time. This proposal accomplishes both of those things. That was the discussion that took place at the Harbor Management Commission.
Last question, you'll be glad to know. The third item of the same memorandum talks about, the temporary facility while this is under construction, which you addressed by saying to someone like myself who was wondering about parking, will that impact adversely the availability of required minimum parking? And I believe your testimony was, no, it will not have that adverse impact because, by the way, we have in the neighborhood of 119 excess parking spaces, if I heard you correctly.
That's correct.
And since you've now informed me anyway that you represent not only this tenant but the landlord, how is it that we ended up with 119 excess parking spaces on site? That seems like a significant number that could have been instead being green space, going back to the open space that you're telling me I can use the Housatonic River, which is off-site, to address your on-site demand.
The extra parking spaces did not result from us constructing additional parking spaces. They resulted from the Zoning Commission passing a zone text amendment that allows so-called shared parking. And when you have a shopping center that's got more than one use, where a person will go there to go to the restaurant, he'll go to the marina, he'll go to Stop and Shop or whatever's there, and he'll do this all at the same time. You don't need one parking space for each one of those uses. And under Stratford's shared parking regulation that went into effect 10 years ago, because that's one of the regulations that I did right, we're allowed a 30% reduction in the number of required parking if you have a situation where you've got more than 200 car parking lot and there are multiple uses where one customer will go to more than one use when he's on the site. So because of the 30% shared parking regulation, the number of required parking spaces dropped. It's not that we added more parking spaces.
Once again, I appreciate the education, and to make sure I understood what I heard you say, initially, upon the development of that shopping center, the 119 were needed, hence that's why they were provided. Since the text amendment was adopted that you wrote, allowing for shared parking, those formerly required spaces now became excess spaces.
That's
Is that
correct.
accurate?
That's right.
Well, now that they are in excess, I'm curious to know, since you brought it up, you represent the landlord as well, have any consideration been given to converting some of those spaces to green space to enhance the aesthetics of your property?
We anticipate additional development in this shopping center that will end up requiring those additional 119 spaces.
I appreciate it's off topic, but I thank you for answering the question. I have no other questions.
Thank you.
Any further questions from the commission? Okay. At this time, is there anyone who'd like to speak in favor of this petition? Please step forward, state your name.
Thomas Yates, 30 Avery Street. Back in 1971, that was the old Y&O coal yard, and I worked over there when we built Bradley's and Stop and Shop. And that far corner where they want to put, where the fishing pier is now, that's where everything drains from the parking lot. Back in 71, there were no requirements for salt or sand separators. I'm just wondering, because this new building is supposed to go in there, is the town required them to put sand and salt drainage structures in there? Like I worked in Milford, I worked in Trumbull. Any new parking areas had to have that in there, okay? Another thing, like I said, the catch basins go through there. If they want to build the building, fine for taxes. But there's one thing I request is Mr. Fredette does not vote for or against this application. Last year, during the election year, he was on the Dock Shopping Center property putting up yes signs, vote for the sewage plant sale, and he also put up signs. You put signs up when you were running for election, all on that property. So I think you're kind of close to the applicant, and you should recuse yourself from voting for this application. Thank you.
I'd like to address that comment, Mr. Chairman, if I may.
Sure.
I am familiar with Stratford's conflict of interest ordinance. Stratford has a very unique conflict of interest ordinance in that it says a elected official has a conflict of interest if he or she stands to benefit, or any member of his immediate family. He, she, or any member of his immediate family stands to benefit financially from the application which they are hearing. That's what our conflict of interest ordinance says, and it's my opinion anyway. From what I was, you can make your own decision whether it applies, but that's what it says.
Yep, that's the way I read it myself. Mr. Florak, would you like to comment on that?
There's. This thing on?
There you go. Yeah.
There's a state statute in Chapter 124 of the zoning chapter of the general statutes that I believe, I'm looking for it now, a conflict of interest exists when elected official or an appointed official sitting on a land use board has a direct or indirect personal or financial interest in an application.
Okay.
So if that exists, a member should recuse themselves.
Okay. Thank you. Ms. Young, you have a statement or question?
Only an observation. I I share what Attorney Knott and Attorney Florick have advised us about how conflict of interest is defined. As a planning professional who has to train board members such as ourselves, we also often talk about the perception of conflict as being equally important to actual conflict. And so the chair may or may not wish to get on the record that although the facts may be accurate, that signage were posted that didn't represent predetermination on your part as to any applications affiliated in front of you. If that were your testimony, and if you felt necessary to say anything, obviously the choice is yours.
I stand not to gain any financial from this decision one way or the other. I feel that I'm within my right as a land use board member to vote free, clear of my mind. Any other member feel differently and want me to recuse myself? Okay, all right. With that, any other member would like to, I'm not quite sure if that was in favor or opposed, but thank you. Anybody else like to speak in favor of? Anybody in opposed?
Good evening, ladies and gentlemen. My name is Walter P. Rimkunis, 425 2nd Avenue, Lordship. Good evening, Barry. I have several questions about this. First of all, this building, 2 stories, is going to be built right alongside Ferry Boulevard, 2 stories. Is this going to any way obstruct the visibility from the road into the parking lot? Number 2, as Mary had brought up, has been brought up several times, signage. He's going to have a sign over there on the entrance to the Dock Shopping Center. He's going to have a building sign on the front of his building. Is there going to be anything on the roof? Is there going to be any type of display on this roof? Or is this just going to be a roof? Having seen the operations going on over there, I'm skeptical. I do not want to see any boats, jet skis, or any other thing pertaining to the use of that building on the roof. The other stores do not have it. I do not believe, I think it should be put in, that there should be nothing allowed on the roof. We already got the boat hanging up there by I-95. But I don't believe it should be allowed. If this is going to be, he's talking about boats and accessories. This is going to be against that other building, marina building over there now that sells all the various types of fishing gear and stuff like that. Is he going to incorporate that, or is it just going to be vehicles, boats and so on and so forth? Is there going to be enough parking close by this building? Because right now, as you come down into Dock Shopping Center, there is a barricade, so you won't run off the road. How does this go according to room for parking in front of the building? Is there enough room? I don't know. I haven't seen any plans or nothing on that. I gotta stop.
Thank you. Anyone else who'd like to speak in opposition? Seeing none, I'll entertain a motion to close by Mr. Hoydick, second by Mrs. Young. Ms. Young? Oh, you just want to waive? Oh, go right ahead, please.
Attorney Knott, would you care to respond to any of the questions you heard from the members of the public before a motion is taken to close the hearing?
Any signage on the building will be in compliance with our zoning regulations. And the police department has already analyzed the location, height, et cetera, of this building vis-a-vis the entrance off of Ferry Boulevard and has no adverse comments with respect thereto.
The gentleman that preceded Walter asked a question about separation of salt before it hits the Houstonic River. Did you get that on the record?
I heard what he had to say. He was talking about when this was owned by the Osborne family in the early 70s. I don't know that it's particularly relevant to this discussion. You've already heard from our engineer as to how the groundwater is going to be handled. I don't know that it's necessary to go into it any further.
Mr. Hoydick?
Clarify.
Oh, sorry, Mary's not done yet.
I'm sorry, to clarify, earlier you said in response to my question that you would agree to a condition there shall be no signage on the roof. Just now, you said something different, which is we will comply with allowable signage.
No, that's
And
not different,
Are
Mary.
they conflict or
No.
the same?
Our signage regulations don't allow signs on roofs.
Thank you.
Yeah, that was going to be my question. Will there be anything more than mechanicals on the roof? You're not going to have boats or any type of apparatus or anything else on the roof?
We could not put anything like that up there without coming actually to this board for a variance, and I don't
just
see
wanted to
that
clarify.
happening.
Yeah, thank you.
Yeah.
I'm sorry to continue to talk about signage, but your client did state on the record that he wanted to address concerns if expressed to him directly, and I may be perceived by him as being confrontational or otherwise negative, and I just wanted to get on the record that when I had the prior concerns related to his signage, I did call his establishment. I didn't speak with him directly, but it was his employees who didn't want to engage with me, which is why I then went to the zoning official to ask for assistance in this regard. And it's been a mystery to me that perhaps can be cleared up tonight by your client. The signage that is on top of the building and visible from 95, I believe it was this board, when I was not on it, that required not only could you have the boat, but this board asked for signage in the form of a welcoming sign to be added, welcome to Stratford. There was
Oh.
discussion that I was at the hearing, sitting where Walter is now, when there was this debate about, well, couldn't you put some message on it? And that's my question is, why, when I'm leaving Stratford, is it welcoming me? Why not tell me, thank you for visiting Stratford, if your client knows?
The Welcome to Stratford sign had to do with the approval for a self-storage facility that was approved by the zoning commission 15 years ago in the location where the gas station is now. We had come in for 125,000 square foot, 4-story self-storage facility, and the then chairman of whatever commission it was, might have been you, asked for
It'd
the
be me.
sign. He wanted a picture of himself and a sign up on the building. We agreed to the sign, but we didn't agree to the picture of him. But no, but that's my recollection of a Welcome to Stratford sign. I wasn't involved in the boat thing. But what difference does it make? It's done.
Because your client posed the question, if people have concerns, I was taking advantage of the opportunity he asked the question to get my question answered, which, to your point, maybe not be relevant, but since we had all the players here, I thought I'd ask the question, but you've answered the question to the best of your ability, for which I'm always grateful. Thank you.
If you need to know, Mary, I requested the sign, welcome to Stratford, because I thought it was time that we open up the dialogue to the public to welcoming people to our town. So all it was is just a friendly gesture. Okay. Where the heck are we? Okay, we're all done with questioning Mr. Knott. I'll entertain a motion to close by Mr. Hoydick, second by Mr. Gregg. All those in favor say aye. Opposed? So moved. That's the motion to close the public hearing portion of the meeting. Up. Oh, okay. Going back to 55 Washington Parkway for 1 second. Gail advised me we do not have a motion to close. I thought we did. Yeah, it was Mr. Hoyt closed and Mr. Tavera.
Okay, let me find it.
No, I kept asking questions.
Okay, all
Yeah,
right,
okay.
all right, sorry.
All right,
sorry.
disregard.
I just want to make sure.
Right. So we have a motion by Mr. Hoyt, second by Mr. Gregg to close
Do you now need a
that
motion?
one. And now I'm looking for a motion to close the public hearing portion.
Motion
Ms.
to
Young?
close the public hearing?
By Ms. Young, second by Mr. Tavera. All those in favor say aye.
Aye.
Opposed? So moved.
Motion to take 55 Washington Parkway off the table?
We have a motion by Ms. Young to take 55 Washington Parkway, second by Mr. Hoyt. All those in favor say aye.
Aye.
Opposed? Do we have any suggestions, any motions to start the discussion part?
I'd like to start the discussion because I gave a preview to the applicant as well as the board members where my struggle lied.
Would you like to start that in the form of a motion, or you?
Well, I'm going to tell you where I'm coming from and then conclude with a motion, but thank you. As the members have heard me ask the applicant about the various aspects of their application, in my opinion, Attorney Knott has addressed comprehensively a number of the standards for which he is seeking relief, but in my opinion, I never got a satisfactory response as it relates to the building height relief. We've heard lots of information about why this use is better than the one it replaces, and we didn't get any testimony from anyone, to my recollection, that challenged that. But I struggle as a planner and as a member of this board about granting relief to height adjacent to coastal resources for which the residents of Stratford and any visitors appreciate that could block those views. And I only have heard financial reasons and rationale for granting the height relief, as it will improve the property values of surrounding property owners, and why this owner will get in the $400,000 range versus a $300,000 range if they get the additional bedroom at the upper level. Never did I hear anything that would relate to any of the case law rationale about reduction in nonconformities, nor did I hear any traditional hardship related to FEMA compliance or anything else from the applicant to justify this height relief and enclosure. My motion is to approve in part and deny in part, to deny the height and grant all other variances. The reasons for granting the variances are as stated on our legal notice and on our agenda. The reason for denying the variance would be failure to demonstrate hardship. That's my motion. I'm looking for a second.
Does everybody understand what you just stated?
Would anyone like me to clarify, or does anyone want to not second and make their own motion? I think that's another choice.
It is another choice, yes. Well, I don't see any other second. So we can carry on, and somebody else would like to make another motion, or does somebody else need more of a clarification from Mary in regards to what her motion actually is? Okay. All right, well, I don't see a second, so I'll entertain another motion. Mr. Hoyt.
Yes, I'd like to also make a motion to approve the application. And I do not have an issue with the height of the building for many reasons. I do think it's a transitional building. It denotes from a commercial area of of Washington Parkway into a residential area. I personally, and it really is an opinion of mine, in traveling up the whole coastline of Connecticut, we spend a lot of time up in Westbrook and in Clinton, and I can tell you that in a lot of the areas where there's commercial as well as high-rises and condominiums, there are buildings that will exceed. Now, they have their own zoning regulations, but they seem to fit and transition in the period into the area. They're aesthetically pleasing. I don't see an issue with the height. And I would just like to make a general motion to approve the application. And I'd also like to cite, with my own opinion, and listening to our town attorney's opinion on non-conforming use of buildings, section 4.2, I believe it applies as a hardship. And I'll just leave it on the floor and see if anybody wants to second it.
I just have one question.
Sure.
Just to clarify. Ms. Young, are you talking about just for its aesthetics, or are you worried about setting a precedent with the height?
Thank you for asking for clarification. In my opinion, the Zoning Board of Appeals actions never set precedent. We look at cases on an individual basis, and what we do today for one property owner will never dictate, in my opinion, what we will do in similar situation on a different lot. Each lot in each case needs to be addressed on an individual basis. My concern is, again, related to the height. We were given exhibits by the attorney not demonstrating how higher this building will be than the single-family home directly adjacent to it and surrounding it, for that matter. And when an applicant comes to this board and sets aside the traditional hardship arguments and instead asks for relief to be granted because of the reduction in nonconformities, that's the rationale this applicant has offered us, not the traditional hardship rationale that we hear from all of our other applicants. It's incumbent, in my opinion, that the applicant demonstrate to the greatest extent that they are not substituting one nonconformity for another, that they are in fact doing as they advertise. They are reducing the degree of nonconformity, which is why I identified to Attorney Knott at the beginning of tonight's meeting that slowly but surely he had persuaded me that the reduction in the setbacks, for instance, did represent, in comparison to the before versus the after, a reduction. Same goes for some of the other standards he sought, but he lost me on height. He is in no way reducing from existing conditions the allowable height. In fact, he's exacerbating by asking for more than what the underlying zoning district allows. That, combined with the impacts to the adjacent property owner, combined with the fact that we're talking about an area that our comprehensive plan tells us is an area we're trying to bring the public to Marnix, to the beach, an area that we are identifying as an attraction for the public, to reduce views by putting up a taller than is allowed under the zoning district building, to me is not consistent with the rationale the applicant has offered of why we should be granting his proposal to quote-unquote reduce the degree of nonconformity. The height doesn't do it for me, which is why I thought a fair compromise was to approve in part and deny in part. The proposal, in my opinion, can be modified so as to comply with the height, and they can still make use of this site in a better way, in a more economic way than the current use. It's not a deal breaker, in my opinion, and that's why I think it's a fair compromise, which is why I made the motion, and if I thought anyone might second it, I'd be happy to make it again.
Well, we already have a motion on the floor that we're entertaining. I spoke to, at the very first public hearing, a couple members of the Second Avenue residents, and not one of them had an issue with the height that this was being proposed. And if anybody would have been affected by that would have been the residents of the Second Avenue. So I don't have any objection at all to this, the height that's being proposed. So we have a motion by Mr. Hoydick to approve. Do I have a second? Second by Mr. Taveras. All those in favor, please say aye. Aye. Opposed? Mary? So it passes 4-1. Item number 2 on our docket, does anybody care to take that off the table?
Make a motion to take 955 Ferry Boulevard off the table.
Motion by Ms. Young to take Ferry Boulevard off the table. Do I have a second? Second by Mr. Taveras. All those in favor say aye.
Aye.
Opposed? Okay. It's our pleasure with this one. Anybody would like to make a motion to start the conversation?
Well, I'll make a motion
Gregor?
to approve because Mr. Knott seemed to answer all my questions, concerns about parking. He's got a letter from Carol Szymanski. She's satisfied with the elevations and the flood part of it. The fire marshal's okay with it. It's going to be off to the side,
Right.
you know, so I make a motion to approve.
We have a motion by Mr. Gregor to approve. Do I have a second? Second by Mr. Taveras. Any further discussion on the matter? Ms. Young?
I wonder if the gentleman to my right might consider a friendly amendment to his motion to capture the agreement that Attorney Knott made during the course of the hearing, which was agreeing to a condition that they will not have signage on their roof as they have had in other parts of the site.
Most definitely, I would agree to that.
Okay, we enter that as a friendly amendment. Mr. Taveras, do you agree with this friendly amendment? Yes.
Yes.
All those in favor say aye. Aye. Opposed? So moved. Passes 5-0. Thank you very much. Merry Christmas. Well, thank you for the short gift. Well, your intentions were good. Okay, I need the approval of the minutes, or motion for approval of the minutes of the November 3rd, 2016 meeting. Motion by Mr. Hoydick.
Second.
Second by Ms. Young. All those in favor say aye.
Aye.
Opposed, so moved. Campsite plan review, 155 Washington Parkway. Motion to approve it? Oh, 55, well, item number 1. Okay. Item number 1, 55 Washington Parkway, we need a motion to approve. Motion by Mr. Hoydick, second by Mr. Grega, the campsite plan. And I need a motion to waive the rules to include as number 2 Ferry Boulevard, because it did not make it on the agenda here.
Did we act on 55 Washington yet, the CAM?
Yes, we did.
I thought you were taking votes. I didn't get a chance to vote.
Oh, I thought,
I-
well, you said
be-
no, you
Well,
didn't say
yes,
anything, so I took
I-
that as a yes.
Forgive me if I didn't hear you. Just for consistency, since I voted no on the first, I'm voting no on the second.
We already voted on it, and I took your no answer as a,
That's an interpretation.
You can withdraw. You can reconsider.
I don't think silence equals an affirmative vote.
right, motion to reconsider the campsite plan review for 55 Washington Parkway.
Motion to reconsider?
Motion by Mr., well, that's to be somebody in the,
Sorry.
Mr. Hoydick, and second by Mr. Grega. Okay, back to the beginning. Campsite plan review for 55 Washington Parkway. Motion to approve? Okay, motion to approve by Mr. Hoydick, second by Mr. Grega. All those in favor say aye. Aye. Opposed? No.
Thank you.
Mary Young saying no, 4-1. Now,
We need a motion to waive the rules.
motion to waive the rules. Motion to waive the rules by Mr. Hoydick. Do I have a second? by Mr. Grega. All those in favor say aye. Okay. To include Ferry Boulevard, 955 Ferry Boulevard on to our agenda for the campsite plan review. Okay, item number 2, 955 Ferry Boulevard, site motion to approve.
So moved?
Motion by Mary Young to approve, second by Mr. Grega. All those in favor say aye.
Aye.
Opposed? Passes 5-0. Members' concerns and/or comments? What?
Members' concerns. You had to
Okay,
know this
well,
was
what are you
coming.
concerned about, Mary?
Coastal site plan review, since that was a topic on our agenda. It would help me as a board member if I had some staff comments identifying what are the coastal resources. Do we anticipate any adverse impacts to them? Do we feel any mitigation is needed before we, in the future, vote on these things? I feel like I'm going in blind when I answer the question of, is this consistent with the coastal area management policies of the state of Connecticut? If I'm given no information, the applicant's not putting it on the record, I think we're taking it on faith every time we say yes. So going forward, I would ask Mr. Hibansky if his staff...
We all trust Jay.
I trust Jay too, but it's good to have it on the record, in my opinion.
Okay.
Sure. And I just to answer to that, where I came from prior, this is not, just because we did it somewhere, I did like this somewhere else, doesn't mean that's right, and we shouldn't do it here. We usually left the comments for any CAM reviews to the state of Connecticut. And if there was any discrepancy or disagreement with the staff comments provided by DEEP, then we would write a separate staff review. If the board or commissions feel like that isn't sufficient, I'd be happy to supplement every CAM application with my own staff comments. So that's the rationale.
I appreciate you explaining how we're doing what we're doing now, because I didn't know, so thank you. It would help me, and again, I may be in the minority, if I had the same benefit that the state had when they gave you comments to know what is it we're talking about. As you know, Jay, there's a coastal resources map identifying for each property what are the coastal resources. And the state, in my opinion, as they have fewer and fewer staff members, have less ability to look at the individual cases that are in front of them, whereas you, in my opinion, are better able to look, because I know you visit all these sites, at what are on site. And in my opinion, I would trust your judgment to determine, for instance, if a rain garden is appropriate or some other mitigation to reduce the nutrient load going into Long Island Sound or whatever the coastal resource may be. And I would be grateful, as one member speaking, for any feedback you could give us, part and parcel with the staff report you're already doing, that speaks to coastal resources when we have a CAM component to a project.
Sure. I'd be happy to do that.
Any other concerns or anything? I'd like to take this opportunity to thank Mary for giving up her birthday to join us this evening and
Happy birthday.
make a quorum.
Should we sing
Thank
happy
you.
birthday in the microphone?
I don't think you want that. I know I don't.
Should be 29, thank you.
Okay. No other concerns or comments. Item number 5, other items. We need to accept the, or vote on the yearly hearing schedule for next year. Is everybody okay with that, or
Could I ask a question,
no?
please?
Okay.
birthday.
Go ahead. One more.
I find it difficult to make a Thursday night meeting, and I know this came up in November because of the election, and I see the 2017 calendar reads the same way, probably because of the election on Tuesday. Is there any reason why we couldn't just do it the following Tuesday if the first Tuesday is problematic, rather than pick a Thursday, which I know will never work for me personally?
Yeah, the following Tuesday, the second Tuesday of every month, is when the zoning commission actually meets.
Problem.
Yeah.
Okay, never mind. Thank you for answering. You won't see me on that Thursday, November, but that gives you plenty of time for an alternate to...
Someone else to fit in there. Okay. Motion to approve.
Just one thing, if I may.
Sure.
The organizational meeting on same day on the 3rd, what does that entail?
You speak into
What does that entail? the organizational meeting?
Organizational meeting is usually when you choose the chairman and the sitting secretary, which is usually the planning and zoning administrator.
Does that take place at the same time, or is that a
No, same night.
same time?
Yeah.
Okay.
Usually the first meeting.
5 minutes before the
Yeah.
meeting starts.
Okay.
Yeah, it's
Thank you.
very minor. It's painless too, usually. Please. Please. Motion by Mr. Hoydick. Do I have a second by Mr. Grega? All those in favor say aye.
Aye.
Opposed? I don't see any. 5-0. Thank you. Motion to adjourn
Make
by
a
Mr.
motion.
Tavares.
My thanks to our acting chair tonight. Motion to adjourn.
Thank you. Second by Ms. Young at 8:31.
Thank you so much.